about you, John?
It's my first time as well.
It's not a big booming voice.
I'm from Texas, and everything's bigger in Texas. Is anybody here from Texas? Yeah. All right. It's my first time here as well, and it's beautiful. I mean, it's 100 degrees and cold. Got here, it was 52, and I was in heaven.
So it's our understanding that we've got some associates here and some folks who are considering being associates. So we're going to talk to you, and really this presentation is intended to be from your perspective, from your shoes. And as you might have gleaned from the topic, the title, yes, you need a will, here's why and how. That's probably a question that, or an answer you're going to give to a potential customer out there one of these days. Whenever you're talking to them about the benefits of the plan, one of the main benefits is the will that we provide for a member in their family. And some folks might say, I don't know that I really need a will. You're going to have an answer to that after you are talked tonight. So, again, John Saltarelli is the managing attorney at Ross & Matthews, the Texas provider firm. I'm managing partner at LegalShield in Pittsburgh, Pennsylvania. Mary Rounds is on call. She's sort of like break glass in case of emergency. We might have to call her up here in case we do something that embarrasses ourselves or embarrasses the shield. So, what we're going to cover today, we're going to talk a little bit about what a will actually does. What happens without a will? We give you 5 real-life situations. I guarantee that one of those is either a real-life situation or somebody that you know. Tips on how to use the LegalShield Will app. You can actually begin the process of getting your will by using the LegalShield app. And then we're going to give you an idea of what happens whenever you click send and that app comes to the provider firm, what happens from our perspective. So, wills, misunderstood and underappreciated. It's something that I think it's on everybody's to-do list because it just seems like that's something that you should do that a lot of folks really aren't sure exactly what they do or why they need to have one. Most people don't have a will, and there's a variety of reasons for that. One is just procrastination, right? People aren't planning on dying anytime soon, so it's not on the top of their list for most people, right?
Not only people just getting their will done that they procrastinate, there's always just so much time that goes by from the time that we actually prepare your will till they get around to signing it. So it's kind of double procrastination. It's just something that you don't want to think about and don't want to do.
Right. This is a great time of the year, by the way, to get wills done or talk to people about getting wills. I find the fall is sort of that time where everybody kind of gets retrenched. Summer's over. Now they get serious before the holiday season comes up. So it's a good time to approach people about it. A lot of people believe that getting a will done is very expensive. And for John's non-LegalShield customers, it is very expensive, right? But not for LegalShield customers because it's part of the membership fee that you pay on a monthly basis. You get them absolutely for free.
And consider the value in that because a will, depending on the complexity, can easily be $500 on the very low end, $1,500, $2,500, depending on the complexity, and up from there, just based on whatever your situation is. So just consider the value of that alone. You'd have free will.
Absolutely. I will tell you that I've been a lawyer for 26 years. John, how long have you been practicing?
31 years.
31. Life has gotten a lot more complex in those 26 to 31 years. There are a lot of complex life situations that we have to deal with, and it isn't all about tax planning, it's just about life planning. A lot of people's lives are very complicated, and it reflects itself in estate planning.
See, I didn't like it when they invented the fax machine. And now look at it.
Notice who's controlling the PowerPoint presentation, not Mr. Technology here. So, a lot of folks don't understand why they need to have a will. Yes, sort of have this vague concept, I need a will, but they don't know exactly why. We're going to try to help you understand what happens whenever you don't have a will today. So, what does a will do? The most basic thing that it does is it directs the distribution and handling of your assets. So whatever it is that has your name on it, whether it's a bank account, car, an IRA, something like that, it can direct the distribution and handling of your assets. It also allows you to appoint somebody that you trust to manage your estate. Basically, to make sure that your wishes are carried out, that your assets that you worked a lifetime for get to those who you wanted to get to. You can appoint, in particular, if anybody has young children, you can appoint a person to care for your minor children. Very, very important. If you don't do that, there's going to be a court proceeding that will have to happen, and the court is going to appoint somebody to care for your children, and it may not be somebody that you would want to care for.
And that this is your chance to make your wishes known. Who do you want to care for your children? Now you can write it down, and now you voted.
Yes, your vote really counts. You get to place age restrictions on minors' access to an estate. You can place age restrictions on anybody's access to the money that you leave to them. So I don't know very many people, in fact, I can't remember the last client that I had that said, you know, the $50,000 or $100,000 I'm going to leave to my son Johnny, and he can have it when he's 18, and he's going to blow it on some hot rod, right?
Absolutely. So I find that the most common age in the wills that we do is age 25, because that's the time that you're typically through with your education, and then you theoretically have a job and you're out there supporting yourself. But there is no restriction. It can be lower than that, or it can be higher than that, whatever your circumstances are.
Yes, we have some extreme helicopter parents who want to withhold that money until their kids are like 65 or something. So we don't have enough money to make that worthwhile. So you also get to make gifts to non-family members. This is where life is complicated, right? Because there are a lot of non-traditional family situations that are out there. Long gone are the days of Ozzy and Harriet, right? Maybe I'm dating myself. That was an old show from the 50s, right? There are lots of unmarried couples. There are same-sex relationships. There are lots of different types of relationships out there, family units, that just don't fit the concept of the laws of intestate succession, right? Which is what happens whenever you don't have a will. So if you don't have a will, what I can tell you is that no matter what state that you live in, the state has a will for you. It's called the law of intestate succession. At least that's what it's called in my state.
And we call it the same, and I can testify to that as well. And the rules are very complicated. Are you married? Are you single? Do you have kids? Are they your kids? Are they my kids? Are they our kids? Is it separate property? Is it community property? Is it real property? Is it personal property? And your estate can go all over the place in a lot of different directions that you wouldn't even have thought of. But that's what's going to happen if you don't have a will, right?
The laws of intestate succession are based on a lot of, I would say, old assumptions of how family units are put together, right? Married, children of that marriage, right? And they are not in step with the types of relationships that are more prevalent in today's society. And the laws of intestate succession have not been changed in a long time, right? Longer than John has been practicing law. So, no will. Here's what happens. I'm going to give you 5 real-life situations. And what I find, at least with the associates that I work with in Pennsylvania find, is that if you can make this real in terms of a customer's life, right? That it creates a sense of urgency, and you can really help them understand the value proposition that you're presenting to them through the LegalShield product, right? You can make it real for their life, for somebody that they know how important it is to have this will, then you create a sense of urgency. So, blended families. Right? We have lots of blended families right now. You may have a blended family yourself. You certainly know somebody that has in a blended family situation. Children from a prior marriage or a prior relationship. Very, very common. Surviving spouse, under the laws of intestate succession in Pennsylvania, right? Your surviving spouse will split your estate with your children from a prior marriage or a prior relationship, right? That can be one prior relationship, that can be multiple prior relationships. That is typically, I find, not what folks want. They would typically want their estate to be available for their surviving spouse, and then ultimately to be divided amongst the children, maybe all the children in the household, or maybe just her biological children.
And that is by far the most jaw-dropping conversation that I've had with members and clients when they have that situation. So imagine this. A couple has been married for 50 years. Now, Texas is a community property state, and that means that husband owns half and wife owns half. It doesn't matter who earned it, who worked, who didn't work. They've been married for 50 years, and they've accumulated all their wealth together. They raised some kids together, great family, great experience. However, the husband had a child 55 years ago from another relationship. Not the wife's child, not much of a relationship with the family. And he died without a will. And because he had a child who was not her child, his half of everything that they worked together their whole lives to put together went to the children and not to her. Now imagine the wife's surprise when you're sitting there, when I'm sitting there with her, telling her, sorry, his half of everything is going over here, you don't get it.
Sorry, you have to sell your house.
That's right. And so when you're sitting at the kitchen table with your prospective member, and they say, why do you need a will? Well, the answer is because you direct where your property goes, and that's it right there.
Right. So if you're meeting with a prospect that's in a blended family situation, or has children from a prior relationship, they absolutely positively need a will, and now you can tell them. Another thing that in blended families is important is guardian for assets left to minors, right? So imagine if you're sitting at the table to say, if you didn't have a will, you've got minor children that you're leaving money to, it's going to go to your ex. Not an exciting proposition for many divorcees, right?
That's correct.
You know,
now your ex is in charge of everything that is there for your minor child.
Right. Not a good situation. So, another real life situation, unmarried couples. Again, very common. Unmarried couples, this was something that was near and dear to my life. I had a friend, Paul, who was dating for a long time. Another friend of mine, her name was Lynn, and they eventually decided to get married after a number of years of dating, very close relationship. Paul passed away suddenly about 2 months before they were supposed to get married. And Lynn got nothing from his estate because he had no will, right? Got absolutely nothing. It all went to his mother, who was very elderly. That was a very sad situation for her, and I'm certain, absolutely certain, that that's not what Paul would have wanted to happen in that situation. But he didn't have a will, and that's what happened. Sometimes in unmarried couple situations, they're living a long time, right? Perhaps one of the spouses brought a house into the relationship, right? And they never retitled the property into the other couple's, the other person's name, right? So the person who owns the real estate dies, and the other member of the couple, who may be living in that house for 20 or 30 years, now cannot continue to live in the house anymore. They don't have any right to continue to live in the residence that they've been living in for a long time.
And that even extends to married couples in Texas. If one spouse brought the home into the marriage and died without a will, the title to the property can go to the kids, although the surviving spouse has a right to live there. But imagine that situation. So the spouse has the right to live there, but the kids own it. Who's going to pay for what? You know, all those different issues. That's a big mess.
Total mess. All of these things that John and I are talking about as we go through these, right? Some of them might be fixable problems, but they're going to cost a gazillion dollars to fix after the fact. Some of them are just non-fixable problems. That's all there is to it. And they are sort of priceless problems, right?
That's right.
But the membership solves all of these problems. These are the types of problems that you are going to enable people to solve or to avoid in their life if you can put a membership in their hands, put the will out in their hands, and speak a little bit of wisdom to them. You will be doing them a tremendous service, their family as well. Other situations, stepchildren, again, this is blended families, there are a lot of stepchildren out there. They're not treated as your children in the laws of intestate succession. You may have raised these children all your life. Another close situation to me, a niece of mine, her name is Jenna, had a child on wedlock. Dad is a ne'er-do-well guy, pretty much not involved in her daughter's life. Jenna is fortunate enough to have found and got married to a very nice physician, and they're having a baby together. And her daughter only knows her husband as her father. That's the father figure in this little girl's life, and will be forever. If they don't get a will done, that little girl is not going to inherit from dad or from her stepfather if he passes away.
And that's fixable by one sentence in the will. It is my intent to treat my stepchildren as my children. And that's all you gotta do.
That's all you got to do. The laws of intestate succession do not speak to stepchildren situations. Single parents, right? Very, very common. Who manages your assets that you leave to your family, to your children? That's a big issue. If you're divorced, you want your ex to be in charge of the money that you leave to your children. I mean, I know some good situations between ex-spouses and caring for children. I know many, many others that are not good, not happy situations. Maybe dad is not involved anymore. If the parent is not around, you don't need somebody to handle the assets for your kids, or live with who the kids are going to live with. There's going to be a court proceeding that is going to determine who your kids are going to live with and who is going to manage your kids' money. So big, big problem. Very, very expensive. Most single people who have no kids think that they don't have a will, right? A lot of people are going to say, I don't think that they have a will. Well, who handles your estate? That's a big issue, right? Who's going to handle your assets? Especially if you're single with no kids. There's no natural person under the law who the law presumes or gives some type of presumption to who can come in and manage your estate. In the probate laws in Pennsylvania, I'm guessing it's probably similar in Texas, when you don't name an executor or somebody to handle your estate, the law will say, in the absence of a will, here are the people, and this is the priority of those who can come in and petition to be appointed as the administrator of this person's estate, right? If you have no kids, really that natural list is just not there. And for some folks that are single, that have no kids, who have elderly parents, they may not be the best people to handle it. Maybe they're in a faraway place, you moved away. We have lots of mobile families these days. Many people don't live where they grew up or don't live close to their parents. So who handles the estate? It's a big problem. It's an expense that you have to go through that you don't need to. It's much more expensive to go through that process than it is to just create the will.
And that's relevant also to where the property goes. Now, in Texas, anyway, you can think of it as a tree, intestate succession as a tree. First, it goes to the roots. If you have kids and descendants, that's first. If no kids, like in our situation here, then it goes up. It goes to the parents. Maybe the parents don't want it or don't need it. Maybe it'd be harmful to their tax or their estate situation to get it from them. If there's no parents, then it goes out to brothers and sisters, nieces and nephews. So it can create issues that are completely unanticipated, involving people who maybe you're not that close to. Maybe the single person has closer relatives or groups of friends or charities or churches that might be their beneficiaries for that single person's will. So it just creates a lot of complexities.
And especially in this type of a situation, you may end up leaving the laws of intestate succession may direct your estate to a family member that you might think that it's a great idea. Woo, get an inheritance, what is that? That's one of the cards in Monopoly, right? You've got an inheritance from an uncle that you haven't heard from in a long, long time. Well, that's not necessarily great news if you are receiving some type of a government benefit that has a resource eligibility requirement, right? And so, especially for single folks that have elderly parents, especially elderly parents that have qualified for and are receiving long-term care medical assistance if they're in a nursing facility, you leaving them that money via the law of intestate succession now renders them ineligible to continue receiving that money. That money will then get spent down, and then your loved one will have to go through the application and eligibility process all over again, and particularly at a time in their life when that's a real challenge for them to do that. Or they may just simply be incapable of doing it because they might have cognitive problems or physical medical problems that prevent them from doing that. You know, elder law, long-term care medical assistance planning is a growing trend with people living longer lives. And the high cost of healthcare, especially the high cost of living in a nursing facility. In Pennsylvania, the average cost is $11,000 a month. I don't know what it is in Texas.
It's a lot, not that much, but it's out.
It's a lot. And so, you know, it's a big deal to be cognizant of where your money is going to go and the impact that it is going to have, especially on family members that have government benefits that have resource eligibility requirements. SSI, supplemental security, I forget what it's called, right? So that has resource eligibility requirements.
Absolutely. We're going to talk about that a little later too. Is one of the things that we need to know about when we take your will information is whether you have any beneficiaries who might be affected by that very issue.
Right. So, if this is your situation, or if this is somebody in your life who knows situation, raise your hand. So your situation, do you know people in these situations? Very, very common situations. So in other words, with all the raised hands, what we can honestly say, as looking at this is, everybody needs a will, right? Everybody needs a will. It's a tremendous benefit. You'll be doing them a favor by putting it in their hands. So, let me hand it over to John to talk about the tips for the will out.
All right. So, I hope that we've made a convincing argument.
Yes.
Yes, you need to have your will. You need to contact your provider firm and get that going. Now, how do you do that? Well, there's a couple of different ways to get the information to your provider firm. One of them is the LegalShield app. And that's the app that's on your phone, and all you need is your phone and your finger. And we'll talk about that in a little bit, about how to go through the app and the kinds of information that we're looking for and what we need. There's also the paper questionnaire that's still out there. That's okay with me too. If you want to fill that out and send it in, contact your provider firm and have one sent to you. And then we'll take that and take it from there. Also, a lot of your provider firms have websites. Ours, RossandMatthews.com, we have a place on our website where you can go in and electronically answer all of the questions on the will questionnaire and just hit submit, and then we've got it. And I'm sure there are a number of provider attorneys who have a similar setup in different states. Okay, so let's talk about the LegalShield Will app. And what I want to try to do tonight is just kind of go through what is being asked and why it's important, so that you understand why it's being asked, why it's important to us, why do we need to know that, and so then you can do a better job of providing to us the information that we need, because you understand why we need it. So starting with your name, your contact information, and your date of birth, of course, so we can identify you, we have an idea how old you are, age tells us a lot. Are you younger or you're older? That tells us a lot about the kinds of issues and questions that we need to be looking for. Marital status, identifying your spouse for obvious reasons. We need to know if you're married, and we need to know how your spouse is going to play in your estate plan.
John, if you answer single, does the whole Match.com thing still pop up? Did they get rid of that?
No, and we don't get any kickback from Match.com. And then asking about the children. Of course, we need you to identify your children, and most importantly, how old are your children? Because as Mike mentioned, minor children need guardians and they need trusts. And we need to know if you have minor children so that we can talk to you about that and get those proper provisions in your room. you have a prenup or a post-nup agreement? This is very important as well, because if you do, then it can have provisions in it that will have an effect on what you can and can't put in your will. So if you tell us that you do have one, we're going to ask you to send it to us so we can look at it. And because we want to make sure that there's nothing in that agreement that is that conflicts with what's in the will, and that you are allowed to do what you want to do in your will. So that's why we're asking about that.
You'd be surprised how many pre- and post-nup agreements there are these days. Again, with the increasing complexity of family units, we're seeing a lot more pre- and post-nup agreements. And as it relates to long-term care, medical assistance planning, and elder law, these are things that are becoming tools of the trade out there in order to preserve your assets and preserve your estate for your family. So there are a lot of more of these around than ever before, I think.
Absolutely. And mentally or physically disabled beneficiaries, we asked you about that as well. That's what we just alluded to with the SSI benefits. We need to know if any of your potential beneficiaries are on SSI. Are they receiving some type of government supplement? Because as Mike explained, if they inherit from your estate, that's going to interfere with the government benefit that they're receiving. So if we know that you have such a beneficiary in your life, then we know that we have to do something different for that beneficiary. We have to advise you about setting up something separately for that person, such as a special needs trust, which allows you to move assets over for the benefit of that person, but in such a way that it does not interfere with government benefits. So that's why that is so important. We need to know about that so we can properly plan for that beneficiary. U.S. citizen, green card holder. Now this has to do with estate taxes. So there is a thing called an estate tax, and that is a tax that is owed on the value of your estate at the time that you die. So we add up everything that you own, and then there's a tax owed that comes off the top. But only if your estate is worth more than $11.4 million. Okay, so most of us don't have to worry about that. So we don't need to worry about elaborate tax planning. However, generally speaking, if you are not a U.S. citizen or you are not a green card holder, it's not $11.4 million. It's $60,000. So anything that you have above $60,000 is subject to the estate tax up to 40%. So we need to know that, because if that is your situation, either you or your spouse, then you need special planning, you need special trusts set up that can at least defer that tax until sometime later.
Well, that would be a good surprise.
It would be a very great surprise.
Yes. In fact, for your family, Uncle Sam took 4 out of every $10 that you own.
So just imagine if you just had a basic insurance policy, $100,000, $500,000 insurance policy. That's well above the $60,000 limit that's going to be subject to estate tax. Okay. And
Don't you love my transitions?
This is the technology. I think I'll hold the clicker for a few minutes. We've touched on this already. Of course, choosing who your executor is very important. That's going to be the person who's in control of your estate, and they're going to be the ones who carry out the terms of the will. Now, in Texas, it's extra important because we have something in Texas called independent administration. That means that once the executor gets appointed by the court, then we're off and running and just getting stuff done. We don't have to report back to the court. We don't have to file accountings. We don't have to get permission to do stuff. We just go do it. So the executor's got to be someone who you know and trust that's going to do a good job in carrying out the wishes and carrying out the terms of your will. The guardian, as Mike mentioned, very important. Now, invariably, this is the most difficult question to answer when a young couple is filling out their will questionnaires. If something happens to both of us, who's going to take care of the kids? Well, how about my sister? No, she's crazy. How about my brother? No, he's weird. How about my parents? No, let's not even go there. So, I mean, invariably, that is the hardest decision to make. Who's going to take care of the kids? But you need to make that decision, and it goes in the will, and it's just super important.
And sometimes those are the questions that can trip people up, even in the process where we've gotten a request to get wills done, and members abandon them or they don't finish them because sometimes they just can't come around to getting an answer to those types of questions. So.
That's right. And you know, we like to encourage everybody to even go beyond that. Who do you want to be the executor? Well, then if that person can't do it, then who do you want to be the second executor? Who do you want to be the next guardian if the first person can't do it? And we put all that in your will so that if something happens, you don't have to keep changing your will. If you have somebody named as executor, but something happens to that person, you've already got the next person's name, so we don't have to keep revising your will. So we try to get as many contingencies built into your will as we can.
Here's the worst question that I don't like to ask guardians, right? So oftentimes somebody will say, all right, like my wife and I. So who's going to take care of our kids? Well, my wife's cousin, Brian and Lisa. People want to often name a married couple that they're friends with, right? So then, of course, as the lawyer, the dumper of cold water on them. Well, if Brian and Lisa get divorced, which one do you want? Who do you like better? Who do you like better? Right? Oh. Then how do you send that to them?
That's right, because it's a good idea to send a copy of your will to these people who are going to have to know something about it at the time.
That's right, because they instantly know who you like better.
And of course, the trustee, you know, that's the person who is going to be in control of the assets for the benefit of the child. Very important selection of who that person is going to be. And then we ask about assets and debts. So why do we do that? Well, we've already talked about the first one, taxes. We need to know if you have a high value estate. Because if you do, then you need more than just the basic will. And so we need to pursue that further and get you the proper estate tax planning that you need. Out-of-state property, that's very important too. We need to know if you have out-of-state property. Because if you do, then there's the potential of having to do two probates. One probate where you live, and then the second one where the property is. So that's a lot of unnecessary expense and a lot of unnecessary time. So if that is your situation, then we'll talk to you about a revocable living trust for that out-of-state property, which can serve to pass that property outside of probate at the time of your death.
Think about that whenever you're doing your own will, right? Because sometimes families have camps or something that have been in the family for a long, long time, and your kids are nowhere close to the camp, right? You live in the Upper Peninsula of Michigan, you've got a camp up there, and your kids live in like Texas and Florida. You may want to think twice and think about asking them, do you want to have some piece of property that's very, very far away from you? You end up with one of these ancillary administrations for an asset that is probably not worth a whole lot of money.
That's right.
It's just a big pain in the rear end. Sooner after a while, just understand what's going on.
Yes,
There are probably ways to avoid probate on this too, so put them in a trust or something.
And then specific requests. So when you're making your will, it can be as simple as, I leave everything to my spouse, or I leave everything in equal shares to my kids. But you can also be real specific. You can say, I leave my house to John, I leave $10,000 to Mary, I leave my timeshare to Mike.
Thanks. Thanks a lot.
And so we need to know those things because we put them in the will. So your will can be as general as you want it or as specific as you want it. And a lot of times it's somewhere in between where you're going to have some specific things and then everything else is going to go to who you say it is. Okay, so that's kind of an overview of the LegalShield Will app. Those are the reasons why you're being asked these questions. Keep in mind, most importantly though, that call us if you have any questions. Talk to one of our attorneys. Every situation is different. You may think that yours is the same as your family member or your friend, but it's going to be different. We need to know about it. And we will contact you because the app does not give us every single thing that we need. It gives us a lot of what we need. It gives us enough information to where we can ask the right questions and get more information from you as relevant, but it's not complete. So we will be calling you and we will be getting additional information from you.
Hey, John, I have a question. If I don't know the answers to all of those questions in the app, can I still send it in partially completed?
You can, yes. And then you can call and talk to one of our attorneys about those issues that you have questions about. And then you can go back and complete your app.
Thanks. I know that I'll accentuate what John said, which is that the app gives us information, but it's a conversation starter, right? And we have found that sometimes members aren't expecting us to call them. They think that if they complete the app, we're just going to send them a will. But we want to have a conversation with them. We're looking to do a high quality job and a thorough job for them. So we definitely want to talk with them about their life situation.
So now you've done that. You have used the app, you've sent us the information, or you've sent us the paper questionnaire, or you've gone on our website and you've given us all the information. So what happens then? Well, we receive that and we open an intake for you. And then we're going to contact you. In my office, we have 4 will paralegals who do nothing but work on these wills. They'll be in touch with you, they'll ask questions, they'll identify issues, and then you'll talk to the attorney. The attorney will clarify some of these issues that we've been talking about or any other questions that may come up. We'll make sure that we have all the information from you that we need and that your questions are answered and that you understand what you're doing and you understand what your will says. Because that's the most important thing, is that we need to know what you want, and then we need you to understand also any of these other issues and that you are getting what is the best thing for your situation. Attorney review, then we'll mail you the will. Now this is important. We mail it to you with execution instructions. When you fill out your will questionnaire, that is not a will. When we mail you the blank piece of paper, the unsigned document, that's not your will. Your will has to be signed. And it's not that simple to sign a will. All states are different, but in mine, for example, it has to be witnessed by 2 people and it has to be notarized. Okay? Now other states have different but similar rules. If somebody took a will that I gave them and they just signed it, it's not a will because it wasn't witnessed. So that's very important. We'll send it to you with execution instructions. Call and ask. A lot of members who are in Fort Worth, they come to our office and sign the wills there.
John, when you say execution instructions, does that mean like by Mr. Green with a pipe in the library?
It does not. It means signing your will.
Signing.
Signing instructions.
Do they have to be notarized in Texas?
They do not, but they're self-proving when they're notarized. So a will just has to be witnessed by 2 people. But in addition to that, if it's also notarized with certain language, then the probate judge will automatically approve it with no questions asked. If you don't have that, if you just have the 2 witnesses, then we have to bring one of the witnesses to court to say that they were there and they saw you sign it. Or if those witnesses aren't available, then someone who can identify your signature has to come to court, and that's how we have to go about getting the will approved. But if you follow the instructions and do it with the witnesses and the notary, then the judge is just going to automatically let it go through.
Highly recommend.
Absolutely, yes. Whatever the procedures are in your state, follow your provider attorney's advice about proper execution or proper signing of a will. And then 5 business days. That's the LegalShield standard that we live by. Whenever we have all the information that we need from you, we have 5 business days to get the will back to you.
We can't even give you execution advice like on the slide, right? Real execution.
So what are you going to get? Okay, you're going to get, in Texas anyway, you're going to get 5 documents back from us. Other states are different because maybe they combine some of these things or they call them something different, but this is the terminology that I use. Okay, you're going to get your will, of course, which is what we've been talking about. And you're going to get your durable power of attorney. Now that's the document where you are appointing someone to handle your affairs for you, but while you're still alive. Say you become incapacitated in an accident or an illness, you make a power of attorney where you say, if this happens to me, then I appoint Mike to handle my affairs. And then he automatically has the authority to do that. He can go to my bank, he can sell my house, he can do whatever I can do. Now, if I didn't have that, and something happened to me, then he's got to become my guardian. And that's a court process, very time-consuming, very expensive. A simple power of attorney just gives him authority over me if something happens to me, over my finances, my business, with just that simple document. And that's all it takes to avoid a big court mess.
Very, very important to have. Very important to have.
And then the medical power of attorney is self-explanatory, similar situation. If you're unable to make your own medical decisions, you're appointing someone to do that for you. The HIPAA release, in In my state, that goes with the medical power of attorney. That simply means that you are releasing your personal medical information to the person who you appointed as the medical power of attorney. So those documents go hand in hand. So whoever you've made your medical agent, under the HIPAA document, they're allowed to receive all of your personal medical information. And then the directive, also known as a living will, that deals with life support situations. In certain situations, you do or you do not want to be kept alive by machines. Now, if that happens to you, and you're in that situation, you're not going to be allowed to vote. You can, because you're on machines. So you fill out that document now, and you state your wishes. In these situations, I do or I do not want to be kept alive by machines.
I find that to be particularly important if you've got more than one child, right? The last thing that I think you would want is for them to have a disagreement about what should happen in that situation for you. And so rather than be mad at one another, just let them be mad at you. You can all settle it at some point in the future when you're all together again. But you know, make that decision for them.
Absolutely.
Really highly encourage them.
Makes it easier on everyone.
Yeah.
Okay, so special situations. Now, we've already talked about this, and so we'll just go over real quickly. Non-U.S. citizens, we talked about that. Different set of tax rules for them. So special planning is required. Special needs beneficiaries. Those who just can't simply inherit from your estate because it'll interfere with their government benefits. They need to be set up with special trusts or other planning outside of just your basic will. High value estates, we've already talked about that. So members with high value assets, they need special planning to deal with either eliminating or deferring estate taxes. And revocable living trusts, out-of-state property, and a lot of people just like to have them in the place of a will. That's not really necessary in Texas, in my opinion, because our probate process is so simple. It's just easier to have a will than to go through probate. But in other states, probate may be difficult and expensive and be something that everybody wants to avoid. And revocable living trusts would be a way to do that by having your assets pass through a trust instead of going through your will and through probate.
John,
And that's something to talk to your provider attorney about.
Can I mention one other special situation? So whenever you're getting your will done, and John said it's a wonderful list of all of the things that are being taken care of just under the plan itself, right? At no additional charge. One other thing that everybody that's doing a will should be aware of is it's not all of your assets are going to pass by virtue of your will. And so if you have life insurance, if you have an IRA, a 401k, a 403b, some other type of an asset or an account that is controlled by a beneficiary form, right? Ideally, you'd be looking at those at the same time that you're getting your will done to make sure that they work in concert with the provisions of your will, right? And especially if you are going to name a beneficiary on that account who may be at an age that is younger than you would want them to have that asset, you will want to make sure that the beneficiary form has specific instructions about the age restrictions and then perhaps points that money to a testamentary trust or a revocable living trust to hold that money until the child reaches the age that you would want them to have that money. I had a grandmother who named all of her grandkids in a couple of life insurance policies, and she did not have a trust. She didn't have the beneficiary form set up to have that money paid into a trust. And so we had to go through a guardianship proceeding to have a guardian of the estate of each one of those grandkids, set up to receive that money several $1,000s later. That's a very simple thing to avoid on the front end if we're doing some planning. So make sure that you talk to your attorney about those types of accounts, and our attorneys will be asking you about those accounts. That's why we get information about your assets, to make sure that you've got a well-rounded plan in place.
Yes, and so keep in mind, it's true in my state, and I assume it is generally everywhere else, beneficiaries override the will. So if you have something with a beneficiary designation, that trumps the will. So you need to make sure that the way you have those things planned is consistent with your will and consistent with your overall estate.
Right. One other special situation, be very careful about retitling your real estate and putting your kids' names on there. That is something that seems like it's a good idea because you want to avoid probate or avoid some death taxes, inheritance taxes. It is fraught with all kinds of problems. And so absolutely, if you're going to think about doing that, call your provider, law firm, and talk to them about whether that's a good idea or not. You invite, it's like becoming a partner with your kids, and you invite all of their personal issues into your property, right? Their divorces, their judgments, their credit problems, everything else. A lot of people they're not aware of all of that. So that's another sort of estate planning special situation. So anyway, so we've probably talked about it enough.
I think so.
Probably bored them to death.
In my state, we have 138,000 members in the state of Texas, and we do probably about 400 to 500 wills a month.
Holy moly!
Yep.
That's a lot of wills.
Yep. So 97% of them are free. They fall under the free basic will benefit under your LegalShield policy. These special situations, I want you to be aware of them in case they're in your life so that you can talk to us about it. But I want you to be aware of them also because those are typically not a free benefit under your will. Those fall under the 25% discount. Just wanted to kind of give you a little disclaimer before I give you the other disclaimer.
And I want to also just point out that what LegalShield has done by putting this will benefit in your plan, right, and having the provider lawyer system, there are not going to be too many law firms in the entire country who have seen more life situations than any of the provider firms in the respective states.
That's right.
I mean, you're doing what, 400 or 500 a week?
A month.
A month, yeah. 400 or 500 a month. I mean, we have seen every life situation, I think, that can be thrown at us. I mean, we are experts at planning for just about every type of a life situation. I did a presentation one time for a financial planning group in Pittsburgh, and I told them, over the last 10 years, we've done 17,000 wills or something like that. I mean, there just isn't a life situation that we have not seen. Right? I would challenge anybody to find any law firm that has done more estate planning than any one of the provider firms.
Well, we thank you for your time tonight.